on Ramadan special EAVA 102.5 FM. I thought that I should start the series with lawyers, and I'm finishing the series with lawyers. So I have got with me, and our theme today is award-winning lawyers, and I have got 3 award-winning lawyers in my studio today. Now, the difference between the program that I did on law at the beginning of the series is that in the first program, I had with you 3 different types of solicitors. I'm being asked to move my... am I all right here? Okay. I'm being asked... thank you. Right. On the first program, we had 3 different types of lawyers, or there were 3 different types of solicitors, and they were in different areas, and there were different... we had Salma from the council. We had different places that you could practice being a solicitor. But today, what I've got in the studio is I've got 2 solicitors, but I've also got a barrister, because I wanted you to hear directly from a barrister to tell you what it's like to be a barrister and what the difference is between being a solicitor and a barrister, and how barristers and solicitors engage together and how they work together. So my guests today are Glynis Wright, who is the Leicestershire Law Society's new president. Glynis, welcome.
Thank you very much, and thank you for having me back on your show.
No, well, I had to have you back on once you became president of Leicestershire Law Society.
Thank you.
But Glynis is an award-winning lawyer, and I'll tell you a bit about her in a minute. I've got Hannah Fountain, who is a barrister. So, Hannah, welcome.
Thank you very much. Thank you for having me.
My pleasure, and I'll tell everybody a little bit about you in a second. And I've got Gina Samuel-Richards, who's a solicitor.
Thank you, Mehmooda.
And I'll tell you a bit about Gina in a second too. So let me introduce my guests. I'm going to say something about each one of them if I can find my bits and pieces here. Let me start with Hannah. So Hannah is a barrister. She's at New Street Chambers. She grew up in Bedfordshire, and she had a state education. So anybody who thinks out there that to be a barrister you need to go to private school, I think that's the first myth that we are dispelling there. She was the first person in her family to go to university. She did a law degree at University of Birmingham, and she, after graduating, she went straight on to complete the bar professional training course at the City Law School in London. She then became a pupil and trained as a barrister at 2 New Street Chambers in Leicester, and she completed her pupillage and accepted a tenancy at New Street Chambers in November 2015. And I'm going to ask you to explain what all of that means to our listeners in a moment, because whilst that means, we don't think about what that means, I think it's important that anyone listening hears about what all of that in lay terms means. And in April 2019, you won Barrister of the Year at the Leicestershire Law Society Awards, and you say that's an achievement you're incredibly proud of.
Indeed.
And many, many congratulations for being that winner. We have another winner in the studio, Gina Samuel-Richards. Gina is a solicitor at AGR Law. You've been around it's your 2nd birthday, so you've been around as a law firm for 2 years, but you have been a solicitor for over 10 years, 11 years. You've worked in national and regional firms. Gina's been she's been living in Leicester since the early 2000s, and alongside her practice, she has volunteered in the 3rd sector. She has sat on a number of management committees and works tirelessly to support the communities of Leicester. As part of giving back, Gina donates advice to management committees of Leicester Rape Crisis and the City Retreat. Both charities meet the needs of vulnerable people in Leicester. She's a member at the Attenborough Learning Trust, and she has recently stepped down as a governor. But Gina's law firm won Small Firm of the Year this year. So both of you were proud winners at this year's Leicestershire Law Society Awards, and congratulations to both of you. But also your most recent appointment at the Leicestershire Law Society AGM was that you've now become a committee member. And I'm sure the Leicestershire Law Society will be delighted to have you on the committee, and we look forward to working with you. So Glynis needs little introduction, because I introduced Glynis to you at some length last time. So, but for anybody who's new to this programme, I'm going to say just a few words about Glynis. Glynis Wright took office as president of Leicestershire Law Society on Wednesday this week. She's the 9th female in the society's 159-year history, and the first woman was District Judge Vera Stamenkovic. That was over 20 years ago. Glynis has some exciting plans for the year, and she will be sharing these with us this morning. Glynis is a late entrant to the law, having become a lawyer at the age of 40. so soon after qualifying, she's holding this prestigious award. Is that this prestigious position? It's not a prestigious award. It's a position, and we're delighted to have you as our president, Glynis. Glynis is also the founder of a specialist family law firm called Glynis Wright & Co. Family Solicitors and Mediators, located in the city of Leicester. So welcome to all three of you. I want you to talk about what you do in your careers. I'm going to start with Hannah. Hannah, you're a barrister.
Yes.
So can you tell our listeners what is the difference between being a solicitor and a barrister?
So the difference between a solicitor and a barrister is that the solicitor is often the first point of call for the client, so they have ongoing conduct of the case, whereas the barrister tends to drop in and out to, for example, represent the client at hearings, maybe have a conference with the client in advance of hearings, maybe give some written advice. So our involvement tends to be focused primarily on representation at hearings, and then we report back to the solicitor, and then we may continue to represent that client at future hearings, but essentially then the solicitor maintains the conduct of that case and has the ongoing involvement and duty to deal with correspondence and the client in that matter. So we don't have direct contact with the client after the point of the hearing.
So predominantly you are an advocate.
Yes,
So-
absolutely.
And an advocate, to anybody who doesn't know what that means, is you're the person who does the speaking and
Yes.
the representing in court. Now, sometimes I get asked this question, that is a barrister above a solicitor, and so can you?
She is flanked by two solicitors.
You can say yes, or
careful.
absolutely. No, but I know what I say to those people. I know the answer that I give. So can you, in your words, explain to our listeners can you answer that? That question?
I think in terms of, I don't think either is more important than the other, because lots of solicitors as well these days have, they have their rights of audience, so they will attend court and represent clients as well. One isn't above the other. I think it's fair to say that perhaps different types of people are attracted to the different, either a solicitor or a barrister. So what I wanted to do, I knew when I went into this profession that I wanted to be the person standing up at court every day, and I had a lot of friends who wanted to be solicitors instead. So I think it's different qualities perhaps, and different aims in terms of what you want from your career. And what I like is being able to drop in, do the advocacy, and then the next day you have another case. But a lot of people have that misconception that one is more important or better than the other, but actually it's not. We both have very, very important roles in terms of different cases and representing clients.
So would it be fair to say that a solicitor's function is different from that of the barrister?
Yes.
That the function is different.
Yes.
So I mean, quite often, if we use the medical profession as an analogy, so somebody might ask, that is a surgeon more important than a physician? So, for example, in cardiology, you might have the cardiologist, the doctor who does all the identifying of what is wrong and do the management and the day-to-day looking after. But once they've identified what the problem is, the surgeon is the one who will go in, do that procedure, and then be done with it. And then they back to the cardiologist, who will then do the day-to-day looking after of that person.
Yes.
So would that be a fair analogy?
I think it probably is, actually, because you can't do it without the other. So barristers really, sometimes, we can do direct access, but actually solicitors have a really important role in enabling us to do our job well as well. And similarly, in that if solicitors want advice from barristers, then we can provide that. So I think we work hand in hand and actually complement each other. So it's probably the same type of scenario, I would say.
So that what do my other panel members think of that, Gina?
I definitely agree with what she's saying.
Can I ask you to come
Sorry.
closer? Thank you. I get told off. I've been told that you need to be kissing the mic. So
Yeah, I definitely agree with Hannah saying it is a difference of function, and they do intertwine. And I know some barristers do direct access, but that really relies on the client to be able to prepare their own paperwork. And a lot of times clients do need solicitors to prepare the paperwork and so forth to be able to then brief the barristers who will go in and advocate on their behalf.
So would you say that it's the art of persuasion that you have? That's your gift.
Yes, absolutely, and thinking creatively, because sometimes you have quite difficult cases to run and difficult instructions from clients, and you have to be creative about how you present that to make it perhaps more appealing than it actually is. So yes, I would say that's persuasion is the key. It's the art really of advocacy.
Or the spin, maybe?
Perhaps, yes, also.
Okay, well, thank you for that, Hannah. Glynis, can I bring you in there?
Certainly.
And what's your take on that in terms of the difference between a solicitor and a barrister?
Okay, well, I would say that the boundaries are merging, actually. We're getting closer and closer together because Hannah, who I might add, I've instructed myself on a number of occasions, who is indeed excellent, a real talent.
Thank you.
She will know that when you get a really good barrister and solicitor team, then it is going to be a well-prepared case. You have chosen your advocate well. You are going into for your client working as a team together. But so much work is done by solicitors in advocacy as well. The boundaries are definitely merging. But what you do when you get a barrister involved is you bring in the pedigree racehorse. That's what I always like to call. I always think of Ascot, with all the horses lined up and, all of the snorting through the noses, and then they go into the court and away they go. And it's fabulous for your client because they've trusted you to be responsible for their case, to prepare it well, and then at the ending comes the pedigree racehorse.
I think that's a lovely way of putting it. And actually, there's a lot of... It's very important that, as you say, that solicitors and barristers work. They have a synergy, don't they? And they work very closely together. And if you've got a good team, that as you say, you can get those top results.
Absolutely, I
so
would
it's
agree.
all in the preparation.
Yes.
Well, it's both, isn't it? It's the preparation and then the delivery.
Yes, performance.
Absolutely. It's learning your lines.
Yeah.
But actually being able to think on your feet.
Yes, that is very, very crucial.
Because it's not a matter of just performing your lines, is it?
No, because you never quite know what's going to be asked of you, whether the judge will ask you a question, whether something crops up in court from the other side. So you have to be able to, and part of that actually is preparation, because if you know your case well, then you will have a response to that. So you always have to be prepared for every eventuality.
So for those people who are listening, if you're thinking, should I be a barrister or a solicitor, then have a little think about whether you like to have that pressure of thinking on your feet, dealing with that, a judge standing there asking you difficult questions, or having curveballs thrown at you from your opponent, and whether you can deliver under that pressure. That's not to say that solicitors don't have pressure. They have different types of pressure, and they equally have curveballs thrown at them at the last minute.
Well, could I add something to that, actually? Because this might help your listeners.
Go on.
If they're actually trying to decide between the path of a solicitor or a barrister, is the solicitor has a long-term relationship with their client, and the barristers very frequently don't. Because you bring them in for the advocacy, they will not have that ongoing work with the client. And so if you're the kind of person who wants to have that relationship, then you're probably going to incline towards solicitors. And don't forget, you can do your own advocacy. I do lots of advocacy. So you're going to have the best of both worlds. Or you'd just like to stand up in court and be this amazing performer, in which case you're going to become a barrister. And I think that might help people.
And I think, some people used to ask me, they'd say, why did I choose to be a solicitor rather than a barrister? And for me, I didn't want to have that last minute pressure of having to stand up or getting papers, very late in the day, and for me to have to get on a train and travel up to Newcastle overnight so that I could be in court at 9 o'clock the next morning. So that kind of pressure for me was untenable, and it's something that I didn't want to deal with. So that played a really important part in my choice of becoming a solicitor rather than a barrister. Do you know, why did you decide to become a solicitor rather than a barrister?
I think for me it was actually having the client relationship. I liked the long-term relationship. I liked actually being on the forefront because I actually felt like I was doing something and I could actually see their lives improving by the work that I was doing.
Yeah.
And I know it does sound a little bit narcissistic, but, it is actually being there at the very beginning when your client comes in broken, you know, a lot of times because, Glynis and I do a lot of family work and they come to you broken, whether it's about contact or whether it's about breakdowns of the marriages. And you sort of counsel them through that process, but you actually can build their case for them very well. And by the end of it, you've got a very good rapport with your client and you're actually achieving their objectives as well.
And you've mentioned that you do family law.
Yes.
Can you tell me why you chose to be a family lawyer? Because, there are so many areas of law that you could practice, but why family? And what does a family lawyer do? Tell us what a family lawyer does.
So as a family lawyer, we look after different aspects of family life. So you're looking at where there is a marriage breakdown or whether people come together and just living together but not being married. We might advise on people's rights of living together and how they might want to split assets if anything should go wrong. Or we might be looking at access to children or which parent the child should live with. And sometimes we do domestic abuse work as well, so actually getting injunctions in to protect the victim and their children if necessary as well. So it's quite a wide breadth, and we are very involved in hand-holding as well.
So there's an element of counselling.
So counselling in the respect of law.
I'm using counselling in a sort of a loose term.
Yes. Because and to be honest, some of our clients really do need a professional counselling to help them through the process because a breakdown of a marriage is like a bereavement. So we will refer our client on to maybe a therapist to help them through that. But whilst we're working on the legal side of things for the client, and it is a matter of counselling, it is a matter of saying to them, this is what realistically can happen. This is what we can do for you. But if you want us to try this as well, we will try it. But you need to be aware, realistically, this is what's likely to happen as well.
So there's an element of managing expectations.
Yes.
And would you say that, do you think that there are times when people come to you with very high expectations of what they hope they will get from the from the process?
Yes.
How do you deal with managing expectations, Gina?
Very gently. You speak to client very gently, and you actually have to lay out for them, this is the path that we will need to go down. And sometimes that expectation is not just about what they think they're going to achieve. Sometimes it's fueled by anger because people are quite hurt by the what's happened in the marriage or whatever the circumstances may be. So sometimes it's about actually talking to that other side of them and get them to calm down and think a bit more rationally, and then going down the route of, well, actually, this is what we're likely to achieve by the end of the case, or if we need to compromise, this is what we might want to compromise on because it might be leaving you vulnerable in another area.
So it's about taking the time to talk to your clients and explaining things that they perhaps are not aware of.
Yes.
Well, thank you. And Glynis, can I bring you in there? You're a family lawyer too.
I am.
And so can you tell me, just before we go into our break, can you tell me why you chose to be a family lawyer?
Well, to be frank, it was something of an accident because I was taken on by a firm and they said, do a seat in family law, you'll be great at that. And I said, I don't really like that idea at all. It's like EastEnders, isn't it? So I didn't actually want to be a family lawyer. But the very first client I saw, I completely engaged with, and I would totally support what Gina's saying. You have to be quite a special kind of lawyer to work on family issues because you have to have the emotional understanding and be able to create a framework that you can navigate your client through of family law in order to get to the end outcome, whether it's child arrangements or whether it's a financial settlement, with your client making proper decisions. So Gina's quite right to say it's not counselling. We have to be aware of the difficulties they're going through, but they have to have faith in us because we are really the ones who are going to carry them through that enormously difficult process. And you have to be attracted to that in law to do that.
And it is a difficult process because you're dealing with people at when they're very vulnerable.
Exactly.
And you've got and there's children involved, so there's nothing harder to deal with than that battle. I'm sure.
Yes.
No, I don't have to deal with that because I'm not a family lawyer, as you all know. But I take my hat off to you in terms of having. And there's an element of a huge amount of emotional intelligence that you've got to have as well in dealing with clients with family law.
And the other thing is, because of the expectation element, actually you have to be not frightened to give the advice that they may not wish to hear, but that they have to understand could be the outcome of their case. Because people will come in with preconceptions. Perhaps, to give an example, a husband who thinks he may not have to support his wife with spousal maintenance after the ending of a marriage. That can be very unattractive advice, but you can't be frightened to give it to them. They need to know the reality.
So we'll come back to that after the break. We're about to go into commercial break. You're listening to Glynis Wright, Hannah Fountain, Gina Samuels-Richards on Leading Ladies, and we're talking to 3 award-winning lawyers. Please engage with us on 07450 925 084 or call in on 0116 212 9324. This is Ramadan special brought to you by EAVA 102.5 FM. Join us after the break. Assalamu alaikum wa rahmatullahi wa barakatuh. You're listening to Leading Ladies on Ramadan Special, brought to you by EAVA 102.5 FM. Please connect with us on Facebook Live, call in on 0116 212 9324, or text on 07450 925 084. I'm joined by Leading Ladies Glynis Wright of Glynis Wright & Co, Hannah Fountain of New Street Chambers, and Gina Samuels-Richards of AGR Law Limited. Now, we are talking about, I've got two family lawyers in the room, and I thought it's a great opportunity for us to have a little think about and talk about Sharia marriage. And where does that lead? So if you had a Sharia marriage, so you had a nikah, but you were not registered under British law, where would that leave the husband and the wife? So you might not would they be recognized? Let me ask you this question. Would they be recognized as husband and wife? They are under Islamic law, but would they be recognized as husband and wife under English law? And where would that leave them were they then to part? Glynis.
It's a really, really important question, Mehmooda. I'm delighted that you're asking it. The fact is that no, as the law currently stands, and it may be changing, but as the law currently stands, they would not be recognised as being legally married under English law. And this has huge implications, because if you're not seen as married under English law, then you're seen as cohabitees. And cohabitees have virtually no rights at all. You'll often hear people talking about common law husband and wife. That is a man and a woman who've lived together for a period of time that have acquired the rights of a husband and wife. There is no such thing. So if you are cohabitees and you split up, particularly if you've got children, you can find yourself enormously disadvantaged, because you cannot apply to the family courts to get the sorts of financial claims that you would expect. For example, spousal maintenance, pension sharing, all sorts of difficulties arise. All you can claim, for example, as a woman who's got children, is child maintenance. Or there are some residual areas of law, such as Schedule 1 of the Children Act, where a woman may be able to claim that she will require a property to live in with a child, but it's a very, very difficult area of law. If she was seen as married, then she would have automatic arguments in court for housing needs to be met. So there is a stark difference between how cohabitees are treated in this country and how married people are treated. So if you're married under Sharia and you also marry under English law, you are in a much, much stronger position. And people really need to be aware of that. And I think there's a huge gap in knowledge out there about that.
So anybody who's listening out there, if that's a question, if you've had a nikah and you haven't got registered under British law, I think the message coming loud and clear from Glynis is that you need to think very, very carefully about having a registry marriage, because nobody wants a marriage to end, but one never knows where things are going to go. And if we could predict these things, we wouldn't need family lawyers. So preparing for the inevitable, were it to happen, make sure that you've been registered under English law.
Exactly.
So that you are protected in the event that you should split it somewhere down the line.
Absolutely.
And Gina, what's your experience of that?
So as Glynis said, it is very similar. I mean, we do have to advise our clients who have only had nikah that their rights are very limited under English law. And unfortunately, we're still looking at around about 61% of people who have married under nikah have not registered their marriages in English law either. But thankfully, the law is changing, or hopefully changing. There has been some consultation as to whether nikah should then be registered without necessarily a civil ceremony, but it ought to be registered under English law. So thankfully, there is consultation that way to try to protect these women. The trouble is then, if you are having these marriages registered under English law, it then sort of steps on the toes of the Sharia, in the sense that husband is entitled to have 4 wives under Sharia law. If one of those marriages gets registered, what happens to the other 3? So that you still end up with another 3 women who may never have that protection under English law. So hence why the consultation is still ongoing. Last year, there was a case as well that got up to the Supreme Court, and this may be a signal for a change. The parties were marriages under nikah only, so under the Sharia, but with the intention to marry under civil law. the marriage it subsisted 20 years, and the husband refused to then conduct the civil ceremony, so they were never married in English law.
So they'd been married for 20 years under
Sharia,
nikah, right?
Yes, indeed. But when it got to the Supreme Court, the judge looked at the circumstances, and it does come down to the individual circumstance of each case. But the judge looked at the circumstances and found that the marriage was actually could be voided under English law, which then entitles the wife to a decree of nullity. So therefore, she could make a claim on the finances under English law. But these are very rare instances, and this is a very distinguished case, and we just don't know where this is going to go under English law at all.
So to simplify matters, if you are in a monogamous marriage, a monogamous nikah, then the safest thing to do to protect your rights in the event of there being a dispute of whatever nature is to ensure that you are registered.
Absolutely.
Okay,
Indeed.
so that's some wise advice, because at the moment, the law as it stands is not protective.
No.
Okay. And and that's irrespective, because I think there may be a misconception out there to think, and I'm glad you brought in the question of the 20 years, that people may think that, oh, but you know what, we've been living together had nikah, and we've been together for years and years and years, and we've got so many children and all the rest of it. We've put everything in together jointly, etc. But you are then still left in that. It's nothing to do with how long you've been married.
Indeed, and nothing to do
Or
with
how many children you've got.
Exactly.
Absolutely.
And the thing about it, if the children are adults, then there are no claims that the maybe the wife can make against the husband, because there are no claims of the children there's no claims at all. So she may be walking away after 20 years of marriage, raising children to adulthood with nothing at all.
And that's a very vulnerable place to be, isn't it?
It is, and might I add, although there are some areas of law that can help people in this position, for example, the law of property, because if that woman has, for example, brought money into the property, paying off the mortgage, helping to pay off the mortgage, or committing capital, she can actually bring claims under property law, but they're hugely expensive, and most people don't have the resources to take that kind of litigation into court. But the residual areas of law that help them are so limited. And this is for men and women. I hasten to add, this is not just about women. This is about men and women cohabitees who do not have the kind of rights that a husband and wife will have. So for all of those reasons, not only under Sharia, but also those who are living together and choosing not to marry under English law, they should think really hard about it, because it does become problematic on breakup.
So thank you for that, Glynis. Thank you, Gina. Hannah, have you got anything you want to add to that?
No, I think I would probably just reinforce what's been said, and actually the key is protecting yourself and your family in the event of a breakup, because we can't ever predict these things, and of course people want to be together forever, but unfortunately that's not always the case, and actually you want to ensure that you have that protection moving forward and the rights and that you can go to court and seek any assistance that you require.
So we have a text message has just been sent in. Hi, leading ladies, I was told when I went to have my children registered that if we got married under English law now, we would need to re-register our children. Is this true? Can we help with that?
I think that's more a question of inheritance, and I wouldn't be able to assist with that.
Yes.
Okay.
With family lawyers, so we
Yes.
don't deal with issues to do with inheritance.
So thank you for sending that text message in. I'm very sorry, but our specialists in the studio are not equipped to deal with that. And that goes back to something that we talked about in the last law programme, which is we are very specialised and we can't deal with those other things. So very, very sorry about that. Coming back to what we do specialise in this room, another area is children. We have another message. Bear with me. Let's just take this before I move on to my next area. What if the wife has assets and she is worried that in the case of the marriage breakdown, the husband is going to try and go after her financial assets? That's the barrier to her registering the marriage. Very interesting point. Ladies, what do we think about that?
Well, that lady is describing a situation where the gender is being reversed, really, because very often in the stereotypical presumptions, it would be the man who has the assets and the woman who perhaps may claim up against those assets, particularly if they've had children. So this lady is in the same position as your stereotypical man, and she may well be better off being married under Sharia law if it's the case case that she's the one with the assets. It would depend on how Sharia law deals with that. But certainly under English law, the man would be able to claim against her assets if she married under English law. That's absolutely right.
So actually, that's put a different perspective on it. So
Depends who's got the money.
well, I suppose, okay, so let's balance that out. So if you want to keep your assets to yourself and not give your partner claim to your assets, were your marriage to break, then don't bother with registering your marriage. But if you want to ensure that you are protected and your wife and your children are protected, and if you want to deal with things with integrity, then it is perhaps better to register your marriage, and then things can be dealt with in a fair and equitable way. Would that be a fair summary?
Yes. An excellent summary. Yes. Well done.
Okay, we just tried to get this balanced. Okay, all right.
Seek legal advice, I think, is the most important.
It is, absolutely. Go and seek legal advice, but just think very, very carefully, because there are, obviously we can see from that, there are pros and cons. So talking about children, I mean, children is a very, very sensitive area, and protecting children. Now, you all deal with children in different shapes or form, and we've got, one of you deals with care proceedings.
Yes, so I cover all aspects of family law, but a part of that hasn't been mentioned on this programme so far is care proceedings. So where social services are involved, perhaps there are concerns about the children not being safeguarded or protected, they may be at risk of significant harm, and it can escalate to the point at which the matter goes to court and the local authority issue care proceedings in respect of those children in order to protect them.
And I mean, do you deal with, Gina, care proceedings, or what area of children law do you deal
I
with?
tend to deal with the private law, so children arrangements. So on the breakdown of relationships, it's discussing where the child should live, how contact should take place. You know, sometimes one of the parents wants to change the child's name and things like that. So we look at the private law aspect of it.
And how do you deal with those issues? I know we've only got a few minutes.
Well, I tend to get instructed by dads who are complaining that they're not getting to see the children. And sometimes, you know, breakdowns can be quite amicable in the beginning, and, you know, they decide dad will have contact every other weekend and do school runs and things like that. But usually something happens, and it's usually about money. And then the agreements break down. And, you know, I usually get dad's instructions saying she won't let me see the children for whatever reason. And it is about saying, well, what has happened? Has there been any safeguarding issues? Has there been any domestic abuse? You know, and looking at the actual relationship a little bit more deeply and saying, well, actually, if there's no issues at all and you're local to the child and you can help with school runs and you can help with after school clubs, I do not see why you're not getting a fair amount of contact with this child. And, you know, a few years ago, there was a whole move towards having shared care and things like that. And we try to move towards that and say, look, the non-resident parent has equal rights to be in that child's life and to raise the child as well, and the child has a right to have that relationship with that parent as well. So we try to find some kind of amicable agreements, and if we can't do that, then it goes to court, and we argue for our client very strongly.
And do you try and avoid going to court, Gina?
Yeah.
Is that sort of, you know, mediation and you know, where does that all fit in?
Yeah, so my family, we're members of Resolution, and Resolution try to do things in family law a lot more amicably, non-confrontational, and we sign up to those code of practices. So we do try to go through agreements and mediation and you know, agreements between solicitors if possible, but we're not going to waste our clients' time in continuing to go backwards and forwards, because it's just a cost to our client. If it looks like it's not going to settle, we get it before a judge and let a judge adjudicate on it.
And Glynis, can I bring you in here about
Certainly.
the effectiveness of mediation, because you are a mediation specialist?
Yes.
Can you talk about mediation and how effective is that in resolving, and how often do you end up going to court? And can you tell our listeners a bit about that?
So for the listeners, a mediation process is where you will have a trained mediator who facilitates discussions between the two parents about the arrangements for children, or alternatively between a husband and wife about what financial settlement they want to achieve. The benefits of mediation is it's so much cheaper. It's so much cheaper than taking a matter into court, but also because it gives control to those two parties to have their discussions. The mediator will be looking to ensure that those discussions don't break down or become abusive or become too emotional to be effective. So they are the facilitators of that discussion. But if two people can come up with their own decisions about what's going to happen with their children on separation, or what's going to happen about their family finances and how to distribute them, they are more likely to have a positive relationship going forwards. They still have to parent their children, even if they're separated and apart. So mediation can be very, very successful. And certainly Gina and also all of the lawyers in my own firm, we do encourage people into mediation where it's suitable.
And so what you say where it's suitable,
Yes.
can you give me an example of where it isn't suitable?
Definitely. So, for example, if we have a relationship where there has been a significant amount of domestic violence, then that may not be a case that's suitable for mediation, although we look at it, and we look at it from the purposes of safeguarding. Can we bring these two people together to mediate? But also sometimes where you have one who may have a very controlling personality and the other who finds it very hard to assert themselves, the mediator will do a huge amount to try to even that playing field. But not every case is suitable for mediation where that positive dialogue can take place. So it's part of the job of a mediator to assess those cases and who could be successful in mediation. That's part of the initial assessments that they make.
So you could have a scenario where you as the lawyer might say, okay, let's consider this case for mediation, but the mediator then comes back to you and says, well, actually, I don't think this is going to work.
They would say it to the individuals
Okay.
rather than to the lawyer, and then the clients would let us know. But yes, absolutely. Or it may be that they've attempted mediation and after one or two sessions, it's clear that the parties are not yet able to move on because sometimes they're so engaged in their emotional dispute that they cannot engage in the positive dialogue. And this is where the point Gina made earlier about therapists. Sometimes people need to go into family therapy in order to work through their issues so that they can resolve things in a more positive and amicable way. And of course, the last alternative for anyone is court proceedings. And any sensible family lawyer would say it is the last alternative and the least desirable.
And I think, Hannah, I'll bring you in there. So if you have that situation, I know you do a lot of family law.
Yes.
So but for you as an advocate, you obviously thrive on things going to court.
Well, I think even when it gets to court, the focus is still on trying to reach an agreement between the parties and hoping that the judge doesn't need to determine the case, because it's always better if the parties can reach agreement between themselves rather than having a decision imposed upon them, that the likelihood being that neither of them particularly like that decision. So, and barristers can still be involved even before it goes to court. Perhaps if they want to get some advice prior to the matter going to court, then a barrister's advice can be sought in advance of any proceedings being issued. But it is always important to try and see whether the parties can agree, because ultimately, if the court makes a decision, the lawyers step away and the parties themselves then have to work with what they've got. So the focus is always trying to make sure it remains as amicable as possible. But of course, that isn't always the case, because it is such an emotive area that people are unable to put their emotions to one side and focus perhaps on what is needed, whether that's the children or what's a reasonable settlement.
And we've got a question up there. So before I ask you my question, let's bring in the question from our listener. So when children are involved, as you mentioned, child support, if the children remain with the father, does that mean the mother should be contributing towards the children's support? So I'll start on this side. Gina.
So under English law, both parents are responsible for the maintenance and upkeep of children. So if the child is living with the father, the mother should be paying maintenance for that child.
Glynis?
Well, I absolutely agree with that. And if you think about it morally, that's right.
Indeed.
It's actually not about men and women or mothers and fathers. It's about where the child spends most of their time and how to make sure the financial support to meet the needs of the child is there in both households. And it's just an apportionment of income in accordance with the proportion of time that the child is spending in each of those households.
So it's about parents taking responsibility,
Yes.
joint responsibility for their children in a nutshell.
Yes.
Okay. So I've forgotten the question I was going to ask. Right. Well, I'm going to ask you about life other than being, well, not life other than being a lawyer, but let's talk about things law, but not law cases. So I'm going to talk to Glynis about her presidency. So Glynis, congratulations.
Oh, thank
Huge
you.
congratulations for being elected president 2 days ago.
Thank you.
How does that feel?
It feels amazing. I have to say, I was very daunted. And so one should be, because it's an important role, Mehmooda, because you, of course, was a president as well, and a fabulous one. But it's such an honour to be representing our members, our barristers and solicitors. It's a role that I want to carry out with absolute integrity. And so I'm looking forward to my year very, very much.
And what things have you got planned?
Okay, well, being a president has some very interesting events. For example, we're going to be, and I'm delighted to announce it, but we're going to be running 100 Years of Women in Law, and we're doing that co-hosting with MALA, the Middle and Asian Lawyers Association. So it's going to be a glittering dinner where we're celebrating the fact that women from all backgrounds, and there are going to be women judges and High Court judges speaking from all of our cultural backgrounds about what it feels like to be a woman in law now, because actually we were only able to enter law 100 years ago.
Which is actually not that long ago.
Which is actually not that long. Before that we were chattels, a bit like dogs and cats apparently.
Okay.
And also we're going to have an event celebrating the amazing things that come out of Leicester, right across the range, law and science and industry. But the much more fundamental underpinning work is making sure that our law society meets the needs of its members, and that we get information out to the public as well of use, important information, law changes and so on. So I'm looking forward to it. I'm hoping it's going to be careful stewardship. And I have to say congratulations to Bushra, our outgoing president, who's done a sterling job. Absolutely fabulous.
Absolutely, she has. And she was on this programme last year when she took over as president, and she has been brilliant. She has been a tour de force, as you mentioned.
Yes.
She's been fantastic. She's been, I mean, she has taken the Law Society to just a completely different level.
I really would prefer not to go after her. It's a hard thing to do.
Bushra, if you're listening, you're a hard act to follow. And
Absolutely.
congratulations, you have been absolutely marvellous and absolutely brilliant. Gina, you are now on the committee, but you have recently, I've got 2 minutes, you've recently won an award. I'd like to talk to both of you about your amazing awards and how you feel about being award winners. So Gina, you won Small Firm of the Year when your firm is only 2 years old.
Yes.
That must feel just amazing.
It is absolutely amazing, Mehmooda. Sometimes it's, pinch ourselves. We can't believe that we won it after only 2 years. When we think about the other firms that we're up against, they were very, very established firms that have been, going for many years longer than we have. Some very tough solicitors. I mean, I've been against a few of them, so I know. And to have grasped that ourselves on our first application for an award as well, it's just absolutely amazing, and very thankful for it.
Oh, well, you should be so proud, because to win an award like that it is difficult. And, the judges are tough. We've got, District Judge Stamenkovic. We've got people from the university on there. I won't name all of our judges, but they're all independent judges, and they are tough. The criteria is pretty tough. Now I've got 53 seconds. So Hannah, you've got 20 seconds to tell us how it feels to be an award winner.
It feels incredibly overwhelming. And I think particularly at quite a young age to have achieved it, I'm absolutely delighted that I received the award of Barrister of the Year, and just a massive thank you to New Street Chambers, who are a huge part of that, and all the support that I received. So it's just genuinely overwhelming, and I feel incredibly honoured to have been given the award.
Well, congratulations to all of you. Glynis, you've won many, many awards over the years, so I'm not going to mention those. I think your presidency is the most important thing at the moment.
It is.
Thank you so much for listening to Leading Ladies. This is our final programme during this month of Ramadan. Thank you for everyone who's listened in throughout the month, and I hope to join you next year. Assalamu alaikum wa rahmatullahi wa barakatuh. Thank you so much.